Good to go? All right, the last case on the docket for the morning is Robert Scott Chandler versus City of Sanford and Janet Daugherty, etc. Morning.
Good morning. May it please the court. My name is Paul McAdoo. I represent, along with Sadie Craig, the appellant Robert Chandler in this public records case. Florida has a long and rich history of providing for citizen access to public records dating back to the late 19th century, when the first statute in Florida permitting such access was enacted. And in the early 1990s, that right of citizens of access to governmental records was elevated to a constitutional one with the enactment of Article 1, Section 24. Consistent throughout the case law in public records is the theme that all actions that result in the evasion of access will be frustrated. Consistent with this theme, statutes are broadly construed in favor of access, and exemptions are narrowly construed.
Oh, they never got to the exemptions in this case, did they?
Your Honor, actually, the oral rulings, if you look at the transcript of the hearing before the trial judge believed, even though the first step in his order was that he did believe that the city was not a proper respondent, he did say that, well, even if they were, it's still a law enforcement exemption, his shorthand for the act of criminal.
But there was no testimony offered to that extent or any argument on it, was there?
There was argument in the papers by Mr. Chandler, and there were references by the city to the exemption itself as well.
All right. Well, other than the law enforcement exemption, were any other exemptions discussed?
At the hearing, I don't believe that the second exemption, which is discussed in the papers of the city, which is the witness victim jeopardy exemption, was discussed in the papers, but I don't believe it was discussed at the hearing itself, because it was addressed in the brief by the city in this case. We've also planned on addressing it, and we addressed it in our reply brief. The first aspect of the trial court's ruling is...
Well, assuming that we agree with you in terms of the fact that they turned these things over to the state attorney's office and felt that was, washed their hands of the obligation, would we not remand it for consideration of exemptions, other exemptions?
Well, I believe that on the record, with the city having asserted both the exemptions in the record below, that this court can consider and rule as a matter of law regarding the application of the two exemptions that were asserted. The first of those two exemptions is the active criminal exemption, and the case law in this state is consistent that a pre-existing record that is then subpoenaed or transferred to law enforcement does not become, in the hands of the original custodian, a exempt record. The first case that I'd like to talk about with that is the second DCA's en banc decision in Tribune Company versus Canella, which was also a death investigation.
And really, what you all are after is an email address. Is that right?
Yes, Your Honor. Okay. Yes, that was as best I can tell, that is what was redacted from the records that were requested. After the petition for writ of mandamus was filed by our client, after not receiving any records in response to his request, he was provided with a redacted copy, PDF copy. So it was also not in the original format. Because
when you say original format, what do you think should have been provided?
Your Honor, under Section 119, or Chapter 119, 119.012F, the custodian of the record has an obligation, if it has it in the format requested, that it should be provided.
Specifically, what is the original format? In
this particular, the electronic record. So a copy of the actual electronic record rather than a printout of that particular record.
And so how should have it been provided? On a disk, on a thumb drive? Forwarded in an email? How do you think it should have been provided?
It could have been provided in any of those settings. It's unclear from the record what system the city itself uses, but the city has a requirement that if it maintains it in electronic format, that it provide it in the format if that's what is requested.
Was there any evidence that that was the way the city had retained it?
No, there's not. And it's for the city, the burden of persuasion and the burden of proof in these sorts of cases where they want to resist access is upon the city.
And another question to that end of what evidence was provided at this hearing, which was really, I guess, a motion to continue. Did the court ever get to the threshold issue that there was a delay?
The court did not get to the threshold issue whether there's a delay. The two key rulings, as I mentioned earlier, were the kind of standing issue, that the city was not the proper respondent, and then his backup oral ruling, which was not reflected in the final order, was that this would have been covered under the act of criminal.
Because the hearing occurred, what was it, after the petition had been filed, but before the city had been served? Is that correct?
No, Your Honor. The petition was filed in early June. There was an order from the court for the city to respond and for the appellant, who was proceeding pro se at that point, to file proof of service. The hearing was held on August 10th, and the way the counsel for the city actually couched what the hearing was at the transcript was that it was a status conference. Mr. Chandler had requested an expedited evidentiary hearing consistent with the Florida statutes, but the trial court held that in his oral rulings that was not necessary. He didn't need to have evidence before him. He felt that he could make his ruling on standing and secondarily his oral ruling on the act of criminal exemption based solely upon the record that was in front of him without any evidence. So we never got to the point where evidence was actually entered. Besides, what you have is the paper trail with the parties. Circling back to the act of criminal exemption, you have Tribune Company versus Canella, where the city had personnel files of 3 officers that were under internal affairs investigation for the shooting death of a suspect during an arrest. And I believe there's a subpoena in that particular case, unlike this case where the record is silent as to whether there was a subpoena or not. It appears it was simply a transfer. And so the personnel files of these 3 officers were transferred to the state attorney. The media in that particular case was seeking access, and in doing so, they were denied access by the city because they said, we don't have them. We transferred them, and they're active criminal. The second DCA rejected that argument, and in so doing, what the second DCA said was, information filed before an investigative process begins cannot be criminal investigative information. In this case, the emails that were requested were from August 2011. The fatal shooting death of Trayvon Martin occurred in late February 2012, and Mr. Zimmerman was arrested in April of 2012.
So is it your position that when a document is created, it is not applicable under any of the exemptions, or it isn't otherwise privileged, there's no event that can occur that could make those documents exempt later?
Well, I'm not sure if there's no event that can occur, but what can't happen is you can't have the transfer of a pre-existing record.
I understand the transfer, but is there any type of event that could occur that would make a document, when it's initially created, it's a public record, but something happens and it is no longer a public record?
No longer a public record or no longer exempt, Your Honor?
No longer either.
It's possible there could be a change in legislation that's considered retroactive. That could change the status of a record. And to be honest, I'm not sure if there's some other exemption that could kick in, but the exemptions that were asserted in this case don't apply because you have consistent holdings from Canella. And Canella was very analogous. Again, it's a shooting death, and it's also what really is kind of tangential information that was swept up in an investigation. I don't think anyone would argue that the linchpin evidence in the Trayvon Martin case was going to be these emails from August 2011. So, and
Now,
Well, it's not just the- I'm
does Zimmerman get any input into this?
no, Your Honor. If you actually look at the Florida Supreme Court decision in Canella, which addressed other particular issues, it's for the custodian of the record to assert exemptions, not for, in that case, the police officers to assert exemptions. An even kind of farther afield case that also supports the non-applicability of the active criminal investigation exemption is what I call the Rilio Wilson case, which is Sun Sentinel versus Florida DCF out of the 3rd DCA. In that case, the DCF, the local sheriff's office, and the local prosecutor were trying to shield from exposure the historical DCF records of a child that had disappeared. And in that case, the court, and it was an emergency petition for certiorari. The court did not have extensive discussion and opinion, but we provided the petition for certiorari in our appendix. But the court held succinctly that the criminal investigative exemption did not apply as a matter of law. And you also have 4 Attorney General opinions that reach this same point, some of which date back to the late 1980s. And so you have this substantial case law that, and Attorney General opinion authority that supports the idea that the pre-existing record does not become active criminal, does not become covered by the active criminal exemption simply because it gets swept up in a later criminal investigation in the hands of the original custodian. Now, we're not arguing whether or not in the hands of the state attorney it would be exempt. It's a different thing in the hands of the particular original custodian. I'd like to talk for a moment a little bit about the other exemption that was asserted by the city below and in their papers, which is the exemption which for victims and witnesses whose safety are in jeopardy, which is embodied in actually the definition of active criminal investigation 119.011. And this is, looking back at the statute, even after we filed our briefs, this is an extremely narrow exemption that has multiple hurdles that the city has failed to clear on each and every step.
Does this court have the authority to consider that exemption, even though it wasn't fully argued or there was any type of evidentiary hearing before the trial court?
I believe that this court can, because it was briefed before this court and was raised below, address it. The exemption itself requires actually that the criminal court find that and order that the information that could be released would jeopardize the safety of such victims or witnesses and impair the ability of the state attorney to locate or prosecute a co-defendant. There's no co-defendant, as we all know, in the Zimmerman prosecution. And there was no finding by the criminal court one way or another that we're aware of. And again, that was the burden of the city to come forward with that. Moreover, as we briefed in our reply brief, Mr. Zimmerman was not a victim or witness in this particular parlance of this statute. He was the person arrested. By mentioning the one thing, it implies exclusion of the other. By failing to mention person arrested as the person whose safety might be in jeopardy, the statute actually operates in a way where it wouldn't apply to Mr. Zimmerman.
Now that the case is over, is your issue moot?
No, Your Honor, it's not moot. The case law is consistent, including cases that we've cited, such as the White Sox case out of the 2nd DCA and the Mazer versus Orange County case out of this court, that a public records case does not become moot if the record is later released, whether that be shortly after or much later after the case is instituted. Your Honors, we ask that the trial court be reversed. The city cannot be relieved of its duties by merely transferring a record to the state attorney as part of an investigation, regardless of the type of investigation. The records are not transformed into active criminal investigative records simply because they're transferred again to the state attorney. They're not when they're a pre-existing record, I'm sorry. And the protections for witnesses and victims don't apply in this case. So we would ask this court to reverse the trial court to order that the city release the record in its original format and unredacted, find that the city had unlawfully withheld the record, and award Mr. Chandler his attorney's fees and costs.
All right, thank you.
Thank you. If I may reserve the remainder of my time for rebuttal.
Yes, sir.
Thank you.
May it please this honorable court, my name is Lamar Oxford. I'm here for the city of Sanford and its lady city clerk. No decision by this court, by a trial judge like Judge Dickey, by the Florida Supreme Court, or especially by the United States Supreme Court, is made in a vacuum. It's made with all the totality of the circumstances considered. The judge is required to apply the law to the facts as he found them. But he can't ignore what's going on that's related to that case, especially when it's so incredibly.
So this is a what's going on exemption to the fact that you can't transfer records? I mean, you're not arguing that the city of Sanford abrogates its public records responsibilities by handing these records over to the state attorney's office, are you?
No, sir, not entirely, but the facts here were not in dispute, which is why I think Judge Dickey was able to go further than just consider the status of the case and consider the city's request that it be dismissed, because Mr. Chandler essentially admitted everything that had happened. That once Mr. Zimmerman was arrested, or perhaps even before that, I'm not certain, the governor appointed the state attorney in the Jacksonville circuit to take over the investigation, given the extreme explosion of media attention and notoriety, et cetera.
But there's no, this is a document that was submitted by Mr. Zimmerman to the city well before any of these things occurred.
Yeah, that's true.
Okay, and
it was given entirely except for his email address. We're here because of an email address.
right, we're here because of an email address.
And the state attorney's office in Jacksonville decided, I'm assuming, that there was enough danger in releasing Mr. Zimmerman's email address to a citizen that that would be the only thing they would redact from this email.
Your argument presupposes that the city could transfer its possession of the documents to the state attorney. And one thing that kept gnawing me as I read these briefs, in this day and age, can a governmental entity ever divest itself of an electronic record?
I'm much more low-tech than you are, I'm certain of that, Your Honor, but I've heard enough stories.
Well, I appreciate the credit, but it may not be well placed.
Well, everyone's heard enough stories, especially in the context of litigation, that there's no such thing as a deleted email.
Right.
Somehow a computer can be hacked into enough to find it.
So it's fine that the city sent, it's fine that the city sent the records to the state attorney, but the city still had possession, even if the city attorney never took the effort to ask anyone, as it says during the hearing, if they still had it.
Right, he said he thought it was highly unlikely that they still had it, and I assume what he was talking about was they didn't have any printout. But the computer also, I assume, was still there.
There's still going to be metadata, as far as that's the term. Metadata will indicate how it's revised, how it's redacted, and the original document as it came in to the office, there's still going to be a record of that. So it's going to be somewhere within the annals of the city of Sanford. And I guess getting back to your argument where you said, Judge Cohen asked you, are you aware of any authority which absolutely transfers responsibility as being a custodian of records from the city to the state attorney's office? You said not exclusively, but partially. My question is, even partially, where is the authority that you would like to point this court to which would establish the ability to at least partially transfer the responsibility for being a custodian of records as to that original email that came in?
Well, that comes back to my original argument, Your Honor, that this case was the dismissal of it. Actually, the request by Judge Dickey to Mr. Chandler to go to where the redaction was made, if he wants to see that one thing that was redacted. That was based upon the conceded facts here, not necessarily some legal argument. I know that there's no such thing as an absolute transfer. Mr. McAdoo has done a good job of showing the case law on that. But in this case, a different entity appointed by the governor to do the criminal investigation of an extremely notorious case, which everyone knew put Mr. Zimmerman's safety in jeopardy, they had decided to make a single redaction. So Mr. Chandler should go to them. They certainly had that public record.
The city simply cannot abdicate their responsibility under 119. I just don't see how that it passes any kind of analytical muster. I'm having a lot of difficulty seeing that.
I know you are, Your Honor, and under the technical application of the law, I would agree with you. But for instance, that the exemption regarding the safety of witnesses and
Victims.
Thank you, victims. It's certainly reasonable to see in this particular case under the undisputed facts of this case, that Mr. Zimmerman was not only a potential witness, despite his right not to testify, but nobody's safety was in more jeopardy than his.
Why doesn't the statute then say criminally accused?
Well, I don't know. I don't know the legislative intent was clearly to protect victims and witnesses. Well, Mr. Zimmerman could qualify as a witness. I don't doubt that he was on everybody's witness list.
Well, but
And it's his
here's
safety that was in jeopardy.
But there's been no evidentiary hearing on that, this was dismissed effectively because Judge Dickey said, well, it's been transferred. You got the wrong party.
As far as who made the redaction, that is true. And there was that. Why would you want the email address? Why wouldn't that jeopardize the
Well,
safety of Mr.
but
Zimmerman?
a 119 request is a 119 request, and we don't delve into individuals' motives behind making those requests. The law provides for it, and we assume the legislature knows what they're doing when they pass these laws, and I don't think his motivation is relevant.
And would we even have the authority to consider that under 119 in the Florida Constitution?
Except for the concept of that exemption, the jeopardizing the safety of a witness.
So wait, we have to consider intent to determine whether or not an individual is a witness or a victim?
I don't think you have to consider intent. Those terms are fairly straightforward. I don't think that because he was the criminal defendant, Mr. Zimmerman didn't lose his status as the most important witness. He didn't testify, but he certainly could have. And nobody doubted, especially Judge Dickey, that it was his safety that was most in jeopardy, and presumably the state attorney had that in mind when they redacted his email address.
But we didn't even get to that, correct?
Because Mr. Chandler didn't take Judge Dickey's suggestion and go to where it had been redacted.
Well, no, because the plug was pulled on the whole proceeding based upon a standing issue, correct?
It primarily is, sir.
So we didn't even get to the point of whether or not a victim and a witness equates to a defendant, and whether or not they're now concerned that Mr. Zimmerman, especially now in light of what's happened in the trial, whether or not he could potentially be a victim, not in this case, but in another case where he potentially could face some type of civil sanction as well. So we never got to that, right? We never got to a full recitation of the facts and testimony on any of the exemptions. It was basically 2 exemptions were addressed by the lower court in passing, but not in detail, correct?
Yes, sir, because the lower court believed that the state attorney could best answer those questions and make that decision whether they would use that witness jeopardy exemption to explain and hold to their redaction of his email address.
I think
It wasn't for the city to decide or explain because the city didn't decide it.
I think it was Tober and the Canella 1 case that used the colloquial phrase shell game, that public entities can't play a shell game by moving public records around. In light of the Tober opinion and the Canella 1 opinion, is there any way that this court could support what the trial court did?
By finding that the facts here are simply different. That the city wasn't trying to hide anything like corruption, which is, I think, one of the original intents of the whole public records law. The city had been ordered to send all their records related to George Zimmerman to the state attorney's office, who were doing an active criminal investigation. So those cases that you're talking about really aren't similar on the facts. Nobody was hiding anything here.
All right, so this is the Marvin Gaye what's going on exception. Is that what I understand you to say?
I would love to hear that, your explanation.
Okay.
Sure.
All right.
Maybe another time.
All right, okay.
But I go back to my point that Judge Dickey didn't make this decision in a vacuum, and neither should this court. And Judge Rodriguez has brought up whether it's moot. I question whether Mr. Chandler goes to the city, or especially to the state attorney's office, and asks for those unredacted records now, just so he can get one email address and doesn't get it.
That brings another question that I had. Were the emails ever produced in the course of discovery, unredacted?
In the course of the discovery.
In the criminal case?
I have no idea.
Because the trial court never addressed that issue.
Right. And we weren't involved in the criminal case, of course. That's Greek to us. We don't think the case decided by Mr. Chandler's attorneys who took over on the appeal are dispositive, because we don't think they involve similar facts. Nothing was being hidden here. No shell game was being played for that purpose. Everyone knew, including the judge, the whole world, that the state attorney in Jacksonville had taken over this investigation. And it was very much still active when this public records request was made. They gave Mr. Chandler everything he wanted, except Mr. Zimmerman's email address. We believe Judge Dickey made a qualitative decision that redaction decision was the only thing left on the public records request, and it should be made to the state attorney because the city of Sanford had nothing to do with it. And let the Jacksonville state attorney explain to Mr. Chandler in court why they thought perhaps Mr. Zimmerman's safety would be jeopardized because of the disclosure of his email address, so that exemption would fit, or simply why that information was part of its ongoing active criminal intelligence investigations. That's what we want to ask the court, not to focus so much on the technicalities of the public records law, because there doesn't seem to be an evil intent going on here. But to focus
it's
on...
a little, it's one thing if you had an IP address, which you might be able to link to a physical address, but an email address is, how are you suggesting that is a safety issue when it's not linked to some physical address?
Well, you and Judge Wallace, I'm certain probably all three of you know a lot more than I do about the high-tech and the low-tech of the computer thing. I can sit there and visualize that having somebody's email address would allow a really professional hacker to get into every email they ever wrote, and perhaps allow that person to feed information to the state attorney about how Mr. Zimmerman was absolutely a racial profiler from 5 years ago on. I don't know why the state attorney decided to redact the email address, but I can imagine reasons that somehow would be important both to the criminal investigation and somehow might jeopardize the safety of Mr. Zimmerman. I think Judge Dickey was just looking at the totality of the circumstances and looking at who had made the redaction, a public entity that Mr. Chandler could simply turn to in writing, making that public records request, and let the battle be joined by the two parties who really were of interest. I'm not saying the city of Sanford was washing its hands completely, but it had a pretty good explanation for what the present status of that situation was.
But that is premised, however, on the concept that you can abdicate your role as records custodian by transferring the documents to another state entity, and that premise is a very shaky premise.
I understand the technicalities of that, Your Honor, but had the city of Sanford done what you're suggesting and given Mr. Chandler a completely unredacted copy of their public record, which included his email address.
There might be exemptions that apply, but the point is that what the city attempted to do was to have a third party make that call instead of doing it themselves and staying in the, and not taking this position that you need to dismiss this lawsuit because you've got the wrong party.
Because the third party had made the redaction decision and...
But the third party got the records from you all, and I just don't, again, I'm struggling to see the legal authority to give a third party the records and say, we're done with it.
Well, what would the city be guilty of had they been ordered by the governor and the state attorney's office, essentially, to transfer all their records related to George Zimmerman to the Jacksonville state attorney, knowing that the state attorney, in response to a public records request, had redacted one thing, and yet the city of Sanford had given that requestor an unredacted copy of everything? What sort of violation of the relationship between the governor's office, the city of Sanford Police Department, and the state attorney would occur there? That is a clear question.
The documents were created in August of 2011, correct?
Yes, ma'am.
And the shooting didn't happen until, what, February of 2012? So when the documents were created, they were not exempt under anything, correct?
Correct.
And so is it your position that an event can happen that will make a public record that was not exempt at the time it was created suddenly exempt?
In very specific factual situations, yes. because-
Is there any case law that supports that?
Not off the top of my head. It's not just the death that occurs. It's also the governor ordering the state attorney in Jacksonville to take over, and that state attorney ordering the city of Sanford Police Department to give us all your records, and then that state attorney's office deciding what to redact when a public records request.
Okay, and you brought up the state attorney's office in Jacksonville now at least 3 or 4 times in this hearing. My question to you is if the 18th Circuit State Attorney's Office had kept the case as it was originally within their jurisdiction and they had ordered the records and had redacted the orders, would it have been a different scenario?
No, sir. I think that the city of Sanford would have violated whatever legal or whatever agreement there is between a police department and a state attorney's office. When the state attorney orders the police department to give us all your records on this defendant, and then pursuant to a public records request that's passed through the city to the state attorney makes a decision to redact. I think that there's some sort of trust between the city police department and the state attorney's office that would be violated if the city gave the citizen who requested the public records more than what the state attorney decided should be. I think that's a very important relationship that has to be respected.
So in every criminal investigation where a prosecuting authority, be it a state attorney, the attorney general, or the U.S. attorney, if they request the records, at that point, any of the records that were subject of that public records request to the law enforcement agency, at that point, all of those records are free for redaction by the prosecuting authority, and the governmental entity that had possession of those records, they are then, it's the proverbial hot potato. It's out of my hands, it's in their hands, you go get it from them, and I am, as Judge Cohen indicated, my hands are clean. Is that correct?
I don't know if it's a clean hands argument, Judge Walsh, but I understand and respect your argument. I do think Judge Dickey was right in telling Mr. Chandler, if you are unhappy with the redaction, then you have to go where the redaction occurred. The city of Sanford is giving you what the state attorney is allowing it to. But the state attorney has taken over these records. And if you want a completely clean record, you go there. How difficult is that? I think it's a very reasonable response, Your Honor, and I don't think the technicalities of the law should invade the province of the judge in this situation. And on the standard of review, where the facts are not in dispute, as here, I think it's very reasonable for us to have pointed out in the answer brief that you have to find clear error. I don't think there's any error here. I think any trial judge would consider this reasonable, how Judge Dickey responded on these specific facts.
All right, thank you.
Were the records produced in their unredacted form?
I'm sorry, Your Honor?
Were the records produced in their unredacted form at any time during the criminal investigation?
Not that I'm aware of, Your Honor, one way or another, and there's nothing in the record on that particular issue. I believe actually the trial judge had some discussion with the city about that, and there also was a lack of knowledge on that particular point. If I may, I'd like to address a few of those points.
Refresh my recollection as to what the substance of the email was.
The substance of the email, from what I recall, Your Honor, is a discussion of a flyer that was going to be used at some sort of a town meeting. I'm not exactly sure past that what the content of the email chains were, but it was a communication from Wendy Dorival, who was the volunteer coordinator for the city of Sanford, to Mr. Zimmerman. And as was pointed out a couple of times now.
But fairly nondescript.
Yes, Your Honor, a relatively nondescript email chain, nothing of particular substance. But I think one of the issues that was raised by the argument from counsel for the city is he mentioned we're here because of an email address, and I think that's incorrect. What we're here for is because Mr. Chandler believes that his constitutional and statutory rights under the Florida law were violated by the redaction, by the shell game that went on here with the city trying to pass on.
No,
its-
we're here for the email address.
Well, Your Honor,
You know, the constitutional arguments are what might get you there, but we're here for an email address.
and as you pointed out, Your Honor, the intent behind whether or not what a requester wants the particular record for is immaterial to the legal analysis regarding the actual issues before the court, including in this instance. And I will tell you, I have no knowledge regarding why Mr. Chandler wants the email address. But he brought suit because it was not, originally because the record was not provided to him at all, and then because it continued because it was later provided to him in a redacted format. I think, Mr. Counsel for the city points out, we can't ignore what's going on here, but what Your Honors has mentioned is there are no judicially created exemptions. The Florida Supreme Court pointed that out in the Waite decision, and we've cited to the Board of County Commissioners versus DB and the 4th DCA for that proposition as well. And what the city has also not done is provided any contrary authority to the host of cases on the multiple legal issues before the court. Judge Rodriguez, you asked whether a city can divest itself of an electronic record. The answer to that question from Mr. Chandler is that it can, but only under consistent with Florida law and the retention schedule that's promulgated under the Florida regulations. But they cannot to do so otherwise. There's essentially kind of a theme that we should have just gone and asked for the record from the state attorney. And Florida law doesn't require that Mr. Chandler chase the record from one custodian to another and continue on in the chain. There's a second DCA opinion of Warden versus Bennett from 1976 that arises in a different circumstance, but talks about, or says, quote, "The fallacy of this reasoning is that it presupposes that simply because the information contained in certain public records might be available from other sources, the person seeking access to these records must first show that he has unsuccessfully sought the information from these sources. The Public Records Act contains no such requirement." And this court has also mentioned that, and Mr. Chandler agrees that there is no legal authority that allows the city to abdicate its duties under 119. There was a kind of a reference to the intent aspect. Well, if you look at the cases, whether it's Cannella, Tober, Wisner, there's no intent requirement with this idea of you can't engage in a shell game. Whether the shell game is intentional or not, it's the result that matters. In this case, the city tried to transfer the records, then wash their hands of the record when it was returned to them, and the 4th State Attorney's Office said, use these in responding to public records requests. That's not what the law requires. The law requires that they, as the original custodian, exercise their legal duties under 119 and provide the records as required by law. So we would ask that this court reverse the trial court, order the release of the records, and find that the city unlawfully withheld the records. If there are no further questions.
Thank you, Counsel.
Thank you very much.
Thank you.
Thank you.
All right, we'll be in recess.